as introduced. Today, I'm very excited to be here, and I'm very happy to have participated in this wonderful symposium. I actually anticipated this AI+ART symposium for a month. It's my great opportunity to expand my thinking, sharing ideas with great artists. And the title of my presentation is The Challenges of AI-Generated Art on the Copyright System. No presenters today spoke from a legal perspective. Of course, I remember Kay's wonderful presentation, which also dealt with some parts of infringement issues. I thank for that. And the world of law is boring and full of incomprehensible terms, legal jargons. So I asked Dali to draw a painting of a presenter like me with a title, and it produced this image for me. Okay. As you might expect, the characters in incomprehensible languages in the back of the whiteboard represents the complexity of the legal system and the legal terms, almost like alien languages. However, I was very pleased to see that the man in the front, the presenter, looks like Brad Pitt in The Legend of the Fall, one of my favorite movies. I hope what I present today is not like the complex and boring things, but like Brad Pitt's movie. So there's a story behind my presentation today. A month or so ago, we had a faculty dinner at my college, and I happened to sit down with Professor Jin-Jun Lee. As I remember, we were both late at the dinner. That was why we were at the same table. And during the conversation, I found Professor Lee's story particularly interesting about his world of arts and how artists create great art pieces. But the thing I remember is that if an artist copied someone else's work, but with a unique method, Professor Lee said that it should be recognized as a unique, great work. I told him that my response was like, in a legal sense, it could be copyright infringement. And we had a very interesting conversation, I remember, talking about many legal examples. So the result, I'm here today. I'm grateful to Professor Lee and Professor Seok-Hyun-Jung for inviting me. Okay, so today's agenda will be like this, and I'll present in the following order. Okay. So my perspective in today's presentation is legal. So let's look at the legal definition of artificial intelligence first. This is what the European Parliament says. Artificial intelligence is a machine's ability, including reasoning, learning, planning, and creating. It's important to note that now AI isn't just something that's being developed quietly in the world of technology. At least since the end of November last year, when the generative AI model was first made public, by the big techs like Microsoft and later Google, every human being has begun to feel the effects of artificial intelligence, especially the generative AI models, whether good or threatening. Some people welcome the incredible creative capabilities of these artificial intelligence. They are excited about the brave new worlds these models will bring us. Others say the exact opposite. They have a great fear of AI exhibiting human-like capabilities. Against this backdrop, the world powers such as the European Union are about to pass a regulation like the AI Act probably next month or end of this year. However, the intensity, the pace, and the focus and regulation method differ greatly jurisdiction by jurisdiction. Writing in The Economist early this year, world-famous best-selling author Yuval Harari diagnosed that new AI tools have hacked human civilization by creating and manipulating words, sounds, and images. So, advanced AI models such as generative AI can have mixed results for humanity, both beneficial and disastrous. As a lawyer, it's a cliche to say that we need to meet some balance somewhere to shape our legal system to maximize the benefits of generative AI and minimize its harm. However, it is in this direction that you can understand my presentation today. So, the three things that Yuval Harari emphasized were words, sounds, and images. I looked at why he asserted that AI has hacked these three things at the core of the human civilization. Here are some examples of how AI can generate words, sounds, and images like as humans. But I have to talk to you today about AI copyright and legal issues. Well, that can be boring and complicated. To help to motivate myself, I've looked at some of AI's amazing intellectual capabilities. First, let's look at AI's ability to manipulate words. I asked Google Bard to write a poem specifically dedicated to this AI+ART symposium. And this is what it came up with within a minute. So, you can read it like AI+ART, a fusion grant where minds and machines unite to stand. A world of wonder yet to be told, where art meets tech, a story bold. Well, the second paragraph I prefer, like with brushes dipped in cool's bright hues and algorithms that inspire and infuse. Artists and AI, hand in hand, create new realms where dreams expand. Well, how do you like it? Second, let's look at AI's ability to manipulate sound. The compositional AI called Beethoven.ai. Well, I asked it to compose a song for AI+ART Symposium. I set the genre to pop, the speed to medium, and the mood to inspirational. There are four combinations of instruments like chords, melody, voice, and percussion. Let's listen to it together, just for 30 seconds. Okay, did you like it? Do you feel like it's inspirational? Give you some insights for the future? Well, it took about 10 seconds to compose this song at the Beethoven.ai websites. Well, third, the ability of AI to create artworks, the fine arts and digital arts, whatever. Well, this is an example from the Colorado State Fair in the United States, which has been in the media a lot about a year ago. The grand prize winner of their annual art contest here September last year was Space Opera Theater. Well, I'll have a chance to talk about this one later, but since we are going to be talking about copyright today, I have a little bit of progress to make first. Namely, just last month in September, a review board at the US Copyright Office determined that this work was not eligible for copyright protection. Well, anyway, they got the first prize. Oh, okay. 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 We've been using the concept of so-called strong AI or AGI. Well, there's been a lot of debates about when it will arrive. The rise of generative AI signals that this strong AI era has already arrived. Anyway, gone are the days when human intelligence was like superior to AI. And now we are entering an era when AI has almost the same intellectual capacity as humans. Of course, we anticipate so-called the super AI era, but even the AGI, the strong AI era will bring major changes and disruptions that have never happened before, just like Yuval Harari diagnosed earlier this year. So the fruits of creativity in the realm of science and technology is invention. So here are the world's first artificial intelligence inventions. It's not that human invented artificial intelligence. It is about artificial intelligence invented some technologies. So the name of the artificial intelligence is DAVOS, which stands for Device for Autonomous Bootstrapping of Unified Sentience. It was developed by Dr. Stephen Thaler. However, Dr. Thaler's role was limited to developing DAVOS, the technologies of artificial intelligence, and DAVOS is said to be doing its creative work. DAVOS has invented a container that can hold drinks and food based on fractal structures. Its another invention is a blinking lamp that attracts people's attention more efficiently. DAVOS became a sensation due to its patent applications all around the globe. Dr. Thaler filed patent applications in many jurisdictions. Well, there's something special about this patent application that in the field for the name of the inventor, Dr. Thaler typed in DAVOS rather than any other names of human being. His claim is that just like no natural person qualifies as an inventor. So I have to type in the name of my machine. So this machine, without any help from any human being, created this technology. It's his claim. And all the patent offices, including the IP office of Korea, rejected this application. But you see the PCT, Patent Cooperation Treaty, administered by World IP Office, named DAVOS as an inventor. So we don't know yet, but the patent offices are discussing what we need to do to handle these cases of patent applications from artificial intelligence. So let's see. Okay, this chart shows the general structure and value chain. I may say the supply chain, whatever you name it, the generative AI ecosystem. Huge data sets accumulated by scraping the World Wide Web as an essential resource for AI. So generative AI models, mostly developed by big tech companies, Microsoft, Google, many others, they are trained on huge amount of data. AI service providers offer pre-trained AI models. If the user is an industry expert, they will learn prompt engineering through more systematic training. The output of the generative AI can be an object for trading. Some artworks can be minted as NFTs and may be sold on trading platforms like OpenSea. This is really a big picture. Recently, a lot of legal issues have emerged in this picture. I have divided into 3 phases of the generative AI ecosystem. First, on the left, in the scraping phase, there are legal issues such as this. like copyrights and information communication technology regulations and computer fraud, unfair competition, blah, blah, blah. Many legal issues, complexities. Well, the training phase, the second one in the middle, contains the legal issues, almost the same thing, but it is about the use of the training data. And there appears some increasing number of lawsuits in courts in the US and some other jurisdictions today. And the third stage, there are copyright issues related to the works produced by artificial intelligence, just like my Brad Pitt image. So the images, do they infringe somebody else's copyright or some other legal issues involved? I'd like to briefly discuss some of the most important copyright issues here. Okay, first legal challenge of this generative AI is on the originality. I mean, the originality is the gist of the copyrightability, whether it is protected by copyright system. So the criteria here is the text from US Copyright Act, like original works of authorship, fixed in any tangible medium of expression. Okay, so this text defines what qualifies for copyright protection. Analysis of the statutory languages will give us this very simple structure, like we have two elements for original copyrightable works. First one is independent creation. Second one, modicum or minimum level of creativity. Okay, well, this independent creation requirement means that you don't copy someone else's work. More precisely, in legal terms, under the copyright law, it means that you don't infringe someone else's copyright. This is different from the novelty, the newness under the patent law. Novelty requires something that has objectively never existed before. So without looking at someone else's work, you may come up with something that is very similar to the original, but you didn't copy it. Patent law would diagnose at the same situation as patent infringement. So that's the difference. Copyright law would not consider it infringement. Okay, the other requirement on the right, modicum of creativity, is a really hard one to clearly define or explain what the modicum or minimum level means. But there's a long line of court precedents about not about what this modicum of creativity means, but about what is not. I mean, which does not meet the criteria of modicum of creativity. There are two things. First one, merger, and second one, scène à faire. Well, this is sometimes called like idea expression dichotomy or idea expression divide. So the merger theory says that only expression of idea, not the idea itself, are to be protected as copyrights. In the 1800s, look at the form, very simple form at the bottom right, like at the center, the Baker versus Selden. This case was involved the copying of a form for double entry bookkeeping, like the accounting terminology. The court held that such a double entry bookkeeping form was merely an idea, so there's no copyright infringement. The same goes for the scène à faire doctrine. The plots, characters, and events that flow naturally from a particular situation are not copyrightable. So look at the clip out there, like a brave man exploring a cave in search of Holy Grail. It's kind of a cliche that falls under the center field theory. On the other hand, what about the Indiana Jones? Think about him. He's a unique character described as Dr. Henry Walton Indiana Jones Jr., who is a professor of archaeology and a great adventurer with an iconic look like bull whips and fedora and leather jacket and sense of humor, depth knowledge of many ancient civilizations and ancient languages, and his sense of humor and, of course, his fear of the snakes, right? So that's not the same explorer, right? So Indiana Jones is copyrightable, not the typical explorer of a Holy Grail. So this is how they define that something is copyrightable or something is not copyrightable. So two things: originality, independent creation, and modicum of creativity. Okay, then what about the, well, considering the independent creation, I told you that there have to be no copyright infringements. Then we need to know how copyrights are infringed. So the term infringement is like a typical legal jargon, may give a negative impression to artists like experts in our industry, yet they also understand that legal system, especially copyrights, it's like a two-edged sword. Like when my copyright is infringed, then the law is on my side, the lawyers are my friends, right? While those who infringe others' copyrights may feel like they want to avoid this legal enforcement. However, everyone in this auditorium may understand that life is complex, because it's not enough to think, I shouldn't infringe someone else's copyright. Being a good citizen, being a good artist is not sufficient. Like, we need to review the copyright system, whether we like it or not. The law is the source of complexity. To find copyright infringement, the plaintiff, the genuine copyright owner, shall prove two things. First, on the left, the original work ought to be copied. I said the term copy here to describe the act of or the behavior of copying someone else's work. But as you may well understand, artists learn to create by copying the great works of others. Well, they will be influenced by other artists. They influence each other, right? When you are in a specific project to create an artwork, you may start by brainstorming, by reviewing others' original works. So the copyright law requires one more component for assessing infringement: the substantial similarity on the right. Okay? It is an assessment to compare original and the allegedly infringing works. So the point is that such a test should be done in view of the general public. I mean, this element put its basis on the art, the copyright's basis on the art industry, right? So artists create, but consumers purchase. So you purchase the artworks in the galleries. And if you are not an expert, then you are like an ordinary observer in the market, and you decide whether the two works are similar or not. So that's what the courts do when they decide whether there is a copyright infringement. Okay, I'm talking a lot. Okay, already. Okay, so I may move to the next slide. Okay, so let's think about the level of creativity required for originality to meet the originality requirements. So modicum of whose creativity? That's my question. So let's look at the painting on your bottom left, like the U.S. Copyright Office And the district court, Washington, D.C., the district court, they don't seem to recognize any creativity in artificial intelligence at all. So you remember Stephen Thaler, Dr. Thaler, the inventor of Davos, the inventing machine. He also created an AI painter. So it's interesting that, for me, it's interesting. I'm talking about the creativity, but the name of this artificial intelligence is Creativity Machine. You can see a painting by Creativity Machine, and it's titled Recent Entrance to Paradise. It's a painting based on the human's near-death experience. Artificial intelligence never die, but anyway, it expressed this idea of near-death experience. Dr. Thaler tried to copyright this painting. I mean, the register is copyright at the U.S. Copyright Office many times, but he was always rejected. So he even went to federal court, but the answer he got from the court was the same thing. Only human being can create works that can be original. In this case, Dr. Thaler was very stubborn, just like he did. He was for the patent application cases. He emphasized that there was no human help whatsoever. So this creativity machine by itself created this work. No human help. Okay. So U.S. Copyright Office and federal court, their view on these AI-generated works is like it gives us the impression that today's, the contemporary copyright laws around the globe will never allow artificial intelligence to come into the realm of human creativity. Well, what do you think about that? Do you think the U.S. Copyright Office and federal courts, they have very strong ideas? They need to change their attitude to be more lenient towards these artificial intelligence works. Well, you can look at the interesting image on your top right. Okay, isn't the image as a cheerleading outfit? And this is a 2017 case in which the U.S. Supreme Court upheld this copyright protection for clothing designs. Very interesting case. Originality was not actually at the issue. So the judge said that we did not just review the originality. But anyway, they endorsed the copyrightability of this design on the cheerleading uniform. My guess is that the Supreme Court assumed that there was a certain level of originality in this simple pattern and color design of cheerleading outfit. Of course, if you read the ruling, they just endeavored to avoid the difficult, complicated legal issues. But anyway, the result is like that. So my question here is like, which do you think is more original or creative? I'm talking about the one bottom left, the work by Creativity Machine, artificial intelligence, and work by some human being, like the cheerleading uniform, the design. Which one looks more original? The court decides that cheerleading uniform, the design, original. I'm not sure, but anyway, they endorsed the copyrightability and some other legal issues. And the recent entrance to paradise. Like, what do you think? So the modicum of creativity is not a hard issue for ordinary copyrightability discussions when it comes to human creation. But when we talk about artificial intelligence and its works, then the courts and government offices, and also many scholars, they felt like reluctant to say that, it has certain level of originality. So, what do you think? Okay. Okay, so let me tell you a little bit about the authorship issue. So currently the copyright offices around the globe, the same thing, their treatment on the originality, about the authorship. Who can be an author of an art? The copyright offices, they refuse to register any works created by machines, artificial intelligence. Which means that no machine, no artificial intelligence can be an author, right? So copyright system currently is exclusively for human beings. So we are all human beings, so we are happy, right? Okay, so you can see the UK Copyright Design and Patent Act, CDPA. In this law, well, there's certain provision that computer-generated works, the authorship of this type of work will belong to the person who makes necessary arrangements. Well, the uniqueness of this law, this provision is that UK law acknowledges that there is some works that is created by non-humans. So no other jurisdiction recognizes this, but UK law well, allows this type of authorship when it comes to this computer-generated works. Maybe my idea is that we can discuss, other jurisdictions also discuss that we may just benchmark this legislation and expand the scope of the coverage of this type of rules to cover the works created by artificial intelligence. Then we can have some sort of authorship. Well, the issue is different, whether there is an authorship and who can be an author. There are two different legal issues. But anyway, I think this UK law's approach is more progressive. Okay, about the ownership, property right issue, simply put, the author owns the copyright. Author owns the copyright. So in many cases, author is the owner of the copyright. Sometimes it's called copyright holder, copyright owner, the same thing. Well, there are some exceptions, like joint ownership. If there are two or more authors with certain intention to create joint works, for example, Professor Lee, Professor Searle, they collaborate and they create something with the intention to create joint works, then they are joint authors. So two authors. And another exception is like works made for hire. Works made for hire under the common law, if you are an employee of a company and you work within the scope of your employment and you produce certain artworks, then your employer will have the ownership. And another type of works made for hire is like the commissioned work or ordered works. Like you may just think about like filmmaking process. There will be a lot of copyrights involved in one project. Then just like Legends of the Fall, Brad Pitt, many like music copyrights and this visual copyrights, many things. And then they want to make it simple. So the company like investing in this project will have this copyright ownership. And all the contributors will have certain portion of this outcome, like as their the reward for their contribution. This is the system. So I show you this works made for hire regime as a good target for our discussion when we talk about contribution of artificial intelligence, and we need to allocate the dividends, the profits out of certain project. Then we can think of this works made for hire regime. We may expand the scope of what is coverage. Then we can have certain level of balance between this benefit of artificial intelligence and we can reduce the negative size of this technology. Okay, and the related question is about legal personality issue. Some people, some scholars argue that we need to introduce some types of e-personality, which means another type of legal personality, just like the corporations and foundations. Not only about natural persons like us, human beings, we have other types of persons in the legal system around the globe. Like companies can own properties, companies can make contracts. Sometimes companies can be get penalties for being not a good citizen, global citizen, by exuding some contaminations, material, something like that. And so this issue about legal personality of artificial intelligence, there goes some talks there, but when it comes to this issue, the monkey named Naruto is invoked. He appears here and there when they talk about copyright and the personality issues. So Naruto was the macaque monkey in Celebes Islands of Indonesia. He took the selfie using the camera of the photographer David Slater. Maybe many of you are aware of this case, and the David Slater wanted to have some profit out of this copyright, right? And okay, so this is about the if we can provide some personality, legal personality for animals, then we can think about personality, e-personality over artificial intelligence. So this is what they are talking about to solve this all challenges the problems of copyright and other legal issues. Okay, so I may just pass to the last slides to complete my presentation today. The last issue on the infringements. So the question is, can AI generate works infringe copyrights of others? So just like me, creating works through DALL-E, Brad Pitt, Presenter, many people are utilizing AI, generative AI models today. And they worry about possible copyright infringements. And the companies providing these services, they, in their terms of use, there goes the saying there is no copyright. We do not claim any copyright from the company side. And you may decide you can utilize these works at your use. But nobody knows how the world will change in dealing with this copyright infringement issues. So you may think about that on your own, because the cases are pending, and we need to just decide whether we should find there is a copyright infringement or not. My view is that it will not be easy to find the copyright infringement, because you know what, the works, the output quite different from any other original works. So maybe we need to think about that. The course will think about it. Okay. So my presentation was about copyright issues and many other challenges and the issues to be discussed. And later, during the question and answer, I may answer to your question. Okay.